So there are two common reasons why heirs contest an estate. One is that the heir believes that the estate is being mismanaged. Something's not being tended to correctly, or the information is not being given, or that their rights in the will or the trust are not being respected. So the second reason that an estate can be contested is that one or more of the heirs was either cut out or minimized, and they think something's rotten in Denmark. And they are challenging the whole trust or the will and saying that somebody procured it by undue influence or by coercion or just taking advantage of the loved one. One thing you've got to understand about disputes over the validity of a will is that they arise over a lifetime. Some people just spend their entire life keeping score in the family, when they were slighted, when they were elevated, who was the favorite, who got more generosity from the parents, all those things. And they just wait for someday to settle the score, settle the accounts. And when your loved one passes away, that's their chance. That's the last chance that they have to settle the score. It's like the iceberg, where you see the top 10% of the iceberg, and there's a massive bulk of ice underneath the surface, and that's the lifetime of keeping score. Undue influence is a close cousin of fraud, and it's the person who manipulates, deceives, lies, shades the truth. It takes advantage of your loved one. Medication sometimes involved, half-truths are involved, rough methods such as taking over the use of your loved one's telephone could be involved, taking advantage of your loved one, at a time when they're under heavy sedation or medication could be involved. Just making the loved one feel like they've got no one in the world that they can depend on, but the manipulator is involved. Disputes over asset distribution can develop probably one of three ways. One is the whole will or trust is being challenged because someone says that the whole situation's not fair. The second way is that there may be a specialized asset. There may be a business or business interest or something that is more complicated than just selling a piece of property and distributing the proceeds. And there's going to be disputes over how to transfer that specialized asset. And the third kind of dispute over asset distribution is really a dispute about communication. Someone feels like they've been left out of the communication loop. No one's talking to them. There's uncertainty. And so in the absence of clear communication, they are assuming the worst, and that they're assuming that you or the executor is up to something. Mediation is extremely effective and helpful for contested estates, especially when the disputes in the family are running high or disputes between two families are running high. A mediator can have a calming presence and also help people to digest the facts and how your case will play out in court. The bigger question is, what does it take to get ready and prepare for a successful mediation? And really, you need to have an attorney at your side to help you get ready to gather the proof and the facts that make your case so that you can make a strong showing in the mediation. If you're involved in a contested estate, you have my sympathy, because I know that emotions are running high and that there's a big fatigue factor that you're experiencing. And you're really looking for a way to get this resolved. If you have any questions about resolving a contested estate situation, give us a call at the Crest Business Law Group.